Hello neighbor, I'm Robert Burns and welcome once again to another edition of Sound Off Louisiana. And I'll let you know that on this one I'm choosing to essentially go the all video route because I'm tired and I just don't feel like typing a lot on a keyboard. So if you looked at our last feature, that entailed fired former LSP trooper Carl Cavalier having sued the State Police Commission. And I think it would be only logical to know that they are not just going to roll over and play dead with regard to that. And I can now tell you that they have done anything but roll over and play dead, as evidenced by the title of our feature. So I'm going to briefly cover their answer and throw in just a few little tidbits of my own regarding the entire situation with Carl Cavalier. This is a blog, so I can interject my opinions, and I'm going to do so in this feature. So we're going to give you the full answer, but in essence, the State Police Commission, acting through its attorney, Lenore Feeney, they are not only answering, but they're giving the affirmative defense of a dilatory exception of an unauthorized use of a summary proceeding. And as a result, if you go to the very last part of Ms. Feeney's pleading, and we will just read it verbatim, wherefore defendant the Louisiana State Police Commission prays that its dilatory exception of unauthorized use of summary proceeding be granted and the case dismissed, and alternatively defendants pray for notice of trial, and that this answer be deemed suitable, and that after all legal delays and proceedings are had, there be judgment entered against plaintiff in favor of defendant with prejudice, and with plaintiff to pay all court costs, expert witness fees, and attorney's fees. Now, I will just say this: I'm not providing the documentation because at $1 a page, things start to run up. But the State Police Commission is subpoenaing Lamar Davis, so it should be interesting to have him on the stand on August the 7th. They're also subpoenaing Jason Hanneman, and they are subpoenaing Diane Pellegrin, who is the attorney for Nooner Pate, and each of their expert witness fees, or let me put it this way, their witness fee is $50, and mileage for, I believe, Ms. Pellegrin total $74, and it was chump change for Lamar Davis and Jason Hanneman, I think about $5 for one, $7 for the other. So you add all that up, $150 in witness fees, and give or take, about $120 for mileage, so you're at $270. The court costs for this are not going to be inexpensive, because Ms. Feeney has also issued subpoenas for the production of documents, and namely, she wants all email communication between Ms. Pellegrin and Ms. Kraft. Ms. Kraft, you may remember, is Mr. Cavalier's former attorney, so that they can evidence this so-called written agreement that Mr. Cavalier has allegedly agreed to. And I just want to say one thing. What's very frustrating to me is that apparently when you're the federal government, you can just have your own set of rules. And here's what I mean by that. If this was you or me, a contract would have to be in writing and executed. And if it's over $500, it's got to be in writing. And good luck for you or me trying to enforce just such an oral agreement for the tiny amount of $200,000. But I guess when you're the federal government, well, you can basically do whatever the blank you want to do, and you can fill in the blank. I find it offensive, quite frankly. Nevertheless, you've seen the court cases that they've cited that said, this is not the first rodeo for enforcing an oral agreement. I still disagree emphatically that there was ever a valid meeting of the minds on here. But as I've said before, it's not my opinion that matters. It's Judge John DeGravel's And I want to say this about Judge Degravel's, and we're going to give you the link for it. I think his own character, in my opinion, needs to be called into question. And the reason that I say that is Judge Degravel's wrote a letter of support for a convicted felon to get his law license back. For those of you who may not know of whom this was prior to him being a federal judge, but for those of you who may not be familiar with Louisiana history, and some of it's sordid past, the former son of the chairman of the Democratic Party of Louisiana, and this was way back when the Democratic Party was far different than it is today, and wielded a pretty good bit of power back then. It doesn't wield very much anymore, as you can probably surmise. But Larry S. Bankston, who was the son of the chairman of the Democratic Party, and we've done features on Mr. Bankston with regard to the FBI wiretaps, so we'll give you the links for those, where he basically emboldened himself and saying, I can make the crooked ways straight, and you know, I want a percentage of the proceeds, okay? I don't want to just be paid by the hour. You can't make any meaningful money just being paid by the hour. I want a cut of the action, all right? You can listen to every bit of, read the transcripts of every bit of it. But Mr. Bankston, after having spent, I don't know, approximately 30 months, don't hold me to that, at facilities other than those that you and I are used to, that is to say federal prison, he sought to get his law license back, and the first attempt he made at it was denied because they said he showed no remorse. I would submit to you, having personally gone up against Larry Bankston when I fought my battles with the Louisiana Auctioneers Licensing Board, and in fact had him as an opponent in court proceedings. I was pro se. It wasn't that easy to get under, wasn't that hard to get under Mr. Bankston's skin. I managed to do it a few times. I take great pride in that. And I don't think he would ever care to encounter me again. But be that as it may, for Judge Degravel's to draft this letter, okay, recommending that Larry Bankston get his law license back, I think speaks volumes. I'll let it go at that. I think it speaks volumes. For you to align yourself and lend your name to this level of corruption. And by the way, we're also going to give you a link for a dissenting opinion. It was from a lawyer from Lake Charles. I did this fairly hurriedly, so I'm going all from memory, but I know I have the link for the dissenting opinion, and I have a much more respect for that gentleman. My point in saying I did all this earlier, I don't remember that gentleman's name. It was a Lake Charles attorney, but I mean, he was emphatic that this sends about as bad of a message to the public about the legal profession as you can possibly send. And I agree with that. All I can tell you is, back then, John Degravel's, but long before he was a federal judge, wrote that letter for Larry Bankston. So I think that speaks volumes to the element with which you may be dealing here. I lost my train of thought because I didn't put any prep into this. I remember it now. And I'm not going to go in and, well, I'll cover some of the high points. I'm not going to give the kind of thoroughness. You can click on Ms. Feeney's pleadings and read all 7 pages of them if you'd like. But she goes out of her way to say that, look, y'all are going to have to provide this agreement now. It's been filed under seal. And therein, to me, lies a big problem of all of this. Everything is done secret, hush, hush. If everybody's so proud of this agreement and thinks it's the right route to go, then why in the world isn't the public being allowed to even see this thing, okay? So now Ms. Feeney says, well, I realize it was filed under seal, but we need to get it because we're now in litigation over the whole thing. I really hope that we get to see it. You know, it looks like the public, the ones that pay the bills, they're going to be the last to get to see the document. So she's requesting that from Ms. Pellerin. Whether or not that'll be entered into the record, and if so under seal, who knows? Wouldn't surprise me because there's been a lot of secrecy in all of this. I also want to point out that I find it really incredible that there was a federal ruling in that case that was about as authoritative for state police as you can imagine. And so it was right in that time frame that they made the $200,000 offer to Carl Cavalier, and I'm still baffled by that. We've previously published it. Not only they brought discovery to a halt, and I'm at a loss as to why you would suddenly, without authoritative of a victory, want to suddenly shove $200,000 down Carl Cavalier's throat, because it defies logic. But I will say this, I mean, perhaps that CNN camera at which he was going to have his hearing, and that was April and May. Now hear what I'm saying, April and May of 2022. If you read over Ms. Feeney's pleadings here, you're going to notice she wants to only cover from September forward, after this $200,000 came into play. And she's going to argue, you can read it, that, hey, all we did was what we were instructed to do by joint counsel, okay? And that may be true from September forward, but you saw the video. We put it in our last feature. If you bothered to look at the video for the last feature, you'll know Mr. Cavalier was in. That's why I love videos. You can bring them back to life, okay? Mr. Cavalier was there. Jill Kraft arguing as emphatically as she could that, by God, he's had to cancel loads repeatedly, and that they were prepared to go forward with these hearings. There was no offer on the table back then. Let me emphasize that there was no offer on the table. And Jill Kraft was infuriated that they couldn't proceed. Why? Because top LSP brass and former LSP brass dishonored subpoenas. I'll tell you what, we'll integrate that part of the video in here again. Let's break away and let's take a look at that part of this whole mess. And I call it a mess. We'll be right back.
His hearings kept getting postponed. And so they kept getting postponed. How was he ever going to be able to appeal his case?
I don't want to continue this. My client is out 200 hours. Behind this, there's a termination because he spoke out. I can't, in good conscience, with a man with 4 kids, say, let's continue it until they decide they want to do their job. But I will suggest that holding the record open, and if I got to call these witnesses back up here and we got to deal with some evidence, I mean, that's how we're going to have to do it. But I don't think because they're state police, they get a pass on not complying with a lawful order.
No one takes the position that anybody gets a pass for complying with the law.
Yes, sir. Understood.
Just 1 second. Ms. Graff, you're certainly alleging misconduct on the part of the state police, is that correct?
Yes, sir.
Okay, well, I would make a motion that we move into executive session to discuss the allegations of misconduct. This did not come up until now, so obviously we didn't have notice of it, so it's not on the agenda. But I'll call for, I made that motion. Do we have a second?
Second.
Okay, we have a motion and a second. Please take a roll call, please.
Brian Crawford.
Yes.
Leonard Knapp.
Yes.
Robert Meir.
Yes.
Howard Puri.
Yes.
Jared Brickey.
Yes.
And Yulia Sini.
Yes. So we're going to go into executive.
He's been terminated from the state police. He currently works as a long-haul trucker. For him to have appeared at the April 14th date with the full expectation that the witnesses would appear and we would have handled this matter meant that he canceled loads, and not just loads for that week, but loads for next week. We're here again today for this hearing. in which my client advised me he also had to cancel loads. He has cleared out his load schedule for the 28th of July to come back. Why are we coming back? Because these people didn't appear in the first place. He's not only having to cancel loads to support his family, but he's also got to pay an attorney, although I'm being kind to him. But I mean, come on. He had to prepare for the hearing on April 14th. He's got to be here. He's doing a long-haul trucking job, which is extraordinarily physically taxing. He takes all that time off, cancels loads, comes here, and they don't bother to show. I would ask that you would consider that. I understand apologies are wonderful. Apologies have a great purpose, but saying I'm sorry doesn't wipe out what you did. And I would ask that you would consider that in enforcing your rights and obligations under 1317. Thank you.
There were procedural things that came up that necessitated those continuances, basically for his benefit, so that he could be prepared to present his evidence, is why those procedural continuances occurred. It wasn't to hurt him, it was to allow him to be able to get the evidence that he needed so that he could, if he had that evidence, prove that the discipline was improper. So it was an effort not to hurt him, but to give him the opportunity to present a full case to us.
All right, so you've seen that it's just flatly not accurate to say that Mr. Cavalier, and I know Eula Simeon had said, hey, everything we did to benefit Mr. Cavalier. The reality is those April and May 2022 dates, they were in place and set to go. There was no offer on the table, okay? And I believe, it's my personal opinion, is this once a big gigantic CNN camera was there, that changed the whole dynamics, all right? We're no longer going to be able to keep this as quiet and as hush-hush as we can. And I believe everything has been hush-hush, hush-hush, hence the secrecy. Have a settlement hearing. Everything's oral, didn't get reduced to writing after, as I'm told should have been the norm for a federal court procedure. It's downright pathetic. And you throw in the element of what I've told you about Judge DeGravel's having written this letter for a convicted felon to get his law license back, and then it starts to become a little bit less difficult to understand why certain things are happening, in my opinion. So Miss Feeney, as on behalf of her client, I mean, they are really telling Carl Cavalier, you know, we're fed up and we're not going to take it anymore. And so they are attempting to collect, I mentioned to you the witness fees earlier, as well as the mileage. As I said, the court costs are going to be substantial, given all that she has filed. I mean, I say substantial, they're not going to be through the roof, but we're talking about a gentleman that's trying to provide for his family now by doing long haul trucking and risked everything, and here we are. And she's trying for attorney's fees. Now, I don't think she's going to succeed there. You know, I talked at length, or discussed at length, the whole Billy Broussard situation, and there simply was no statutory provision for awarding them. And you know, you can always ask for it in your prayer for relief. I would be stunned if Judge Johnson granted the attorney's fees, but then again, to quote Eric Ike, a judge can do whatever he wants to do. I don't know. I was there and I witnessed him say that, so I'm laughing a little because some of the things that you see take place in Louisiana courtrooms are interesting. Let me just put it that way. So I will be there. I really hope that courtroom will not be empty. Well, I know it won't be empty, but you know, who knows? Maybe even another media outlet besides Sound Off might choose to attend, and we'll see what happens. But I did want to give you State Police's response. They are, I say State Police, I'm sorry, the State Police Commission's response. Clearly it's hardball, as hardball as you can play. I guess to sum it up, they literally are saying we are fed up with Carl Cavalier and we're not going to take it anymore. So you can feel free to read the entirety of the pleadings. They're only 7 pages. but I've kind of hit the high points. There are some other developments, and we're gonna be having some interesting features coming out real soon. Believe it or not, won't directly have to do with state police. So I want to thank everyone, and for those of you who liked videos over reading, this one should have been very pleasing to you. So we will be there on August the 7th, even if there's no other media outlet there, because we try to keep our subscribers and our casual site viewers as up to speed as possible, and that's what we have attempted to do with regard to this filing, which I believe was made on Thursday or Friday of last week. Thank you once again, and we look forward to seeing you again real soon on another Sound Off Louisiana feature. Thank you once again.